Karen yelled across my lawn at sunrise. This grass is 0.1 inches taller than the HOA regulations. You owe $10,000. I leaned on the porch railing, calm as ever, sipping my coffee. Funny, I muttered, she doesn't know who she's dealing with, or that I've argued cases far bigger than her HOA nightmare. Karen's clipboard wobbled in her hands. You can't talk to me like that, she screamed. I just smirked, leash in hand, as my K9 growled softly. Oh, I can, and I will, in court if necessary. Neighbors peeked from behind blinds. Neighbor 1 whispered, Is she really yelling over grass again? Neighbor 2 replied, I think she's finally met her match. Karen stomped down the sidewalk, papers flying. Mr. Miller, this grass is too tall. $10,000 in fine starts today. I stepped onto the porch, calm. Ms. Karen, I think your measurement is imaginative. Imaginative? Do you see this grass? I have the authority, she snapped. Authority to enforce rules, yes, but not to extort $10,000 for a 0.1-inch difference. That's not legal, I said. Her jaw dropped. Legal? I can send this to collections. Go ahead, I replied, straightening my tie. But remember, I prosecute cases like the one you're trying to manufacture. Karen huffed and left, muttering about filings and fines. By noon, the formal notice arrived, a $10,000 HOA complaint. I called my colleagues. We're going to dismantle this. I said, this is harassment and abuse of HOA power. We'll reference municipal law, bylaws, and precedents. Karen believed she had the upper hand. She didn't know that the first hearing would humiliate her. The courthouse buzzed with curiosity. Reporters, neighbors, and a few lawyers waited. Judge Harris called the session. We are here for the HOA complaint against Mr. Miller. Ms. Karen, present your case. Karen cleared her throat. Your Honor, Mr. Miller violated Section 4B of the HOA landscaping rules. The grass is too tall. I demand $10,000 in fines. I rose calmly. Your Honor, this claim is petty and legally baseless. 0.1-inch deviations do not justify $10,000 fines. HOA rules cannot override state law. Ms. Karen's demand constitutes harassment. Karen shuffled her papers. But the board approved this. The community expects compliance. Compliance must be reasonable. 0.1 inches is negligible. I also file a counterclaim for $50,000 for harassment and legal fees. I said, Judge Harris raised an eyebrow. Mr. Miller, you are a prosecutor? Yes, Your Honor. I have argued dozens of HOA abuse cases in higher courts. I replied. Karen paled. She thought intimidation would work. She hadn't counted on facing a legal professional. Judge Harris. Ms. Karen, claims must be reasonable and documented. Mr. Miller, you may file a countersuit if warranted. Karen tried to interject, but my 0.1-inch measurement, even if precise, it doesn't meet lawful penalty standards, I said. The gavel struck. Karen slumped. The absurdity of her claim was unraveling. Neighbor whispered, Did you see that? She just got called out by a prosecutor. I smiled faintly, knowing the next hearing would seal accountability. The courtroom was packed. Karen clutched her papers, sweating. He can't win. He's just a homeowner, she muttered. I calmly opened my folder. Funny, I enforce cases like this all the time. Judge Harris adjusted his glasses, scanning Karen's documents skeptically. The tension was electric. The moment before the courtroom showdown. Judge Harris, we are back in session regarding the HOA complaint. Ms. Karen, proceed. Karen shuffled nervously. Your Honor, the defendant flagrantly violated the landscaping rules. Grass exceeds limit by 0.1 inch. $10,000 is reasonable. Courtroom murmurs. I stood composed. Your Honor, 0.1 inch is statistically insignificant. Fines imposed without legal basis are harassment. This is legally untenable. Karen, the bylaws allow escalating fines for repeated violations. And they also require reasonableness, which you ignored. Charging $10,000 is punitive and baseless. I am filing a counterclaim for $50,000 for harassment and legal fees, I stated. Judge Harris leaned forward. Do you have precedent, Mr. Miller? Yes, Your Honor. Smith versus Willow Creek HOA. 2019 dismissed a $7,500 fine for minor lawn deviation. Anderson versus Pine Ridge HOA. 2020 found disproportionate fines unenforceable. Ms. Karen's $10,000 demand for 0.1-inch deviation mirrors these cases. Karen's mouth opened, but no words came. Furthermore, Your Honor, harassment and emotional distress justify the counterclaim. I said. Karen stammered. But I'm enforcing community rules. Rules cannot override law or fairness. She weaponized HOA regulations for personal gain. I explained. Judge Harris, Ms. Karen, fines must be reasonable. $10,000 for 0.1-inch fails is standard. Mr. Miller's counterclaim is valid. He is awarded $50,000 in compensation. Case dismissed. Karen gasped. Neighbors whispered. Even reporters froze. The authority flip was complete. A seasoned prosecutor had outclassed HOA Overreach. Karen sat stunned, papers clutched, her attempt at dominance dismantled. Reporter, Ms. Karen, your reaction? Karen, the bylaws. I remain composed, gather my files. Neighbor 1, I can't believe she bullied you for years and finally got called out. Neighbor 2, the lawn was 0.1 inch taller, unbelievable. I smiled faintly. Rules exist for reason, but cannot override law or common sense. Karen's reputation collapsed. The HOA board whispered about liability and financial disaster. I filed the $50,000 compensation paperwork. Money aside, it was a lesson in accountability. Back home, I sipped coffee on my porch, lawn perfectly trimmed. Some battles are fought over lawns, others over principles. Today, both were won, legally, fairly decisively, I said, smiling.